fired hours after you refused to agree to the Deputy Attorney General's demand that you sign your name to a memo and that you recommend that Mel Gibson, a convicted domestic abuser who also happens to be a friend of Donald Trump and his special ambassador to Hollywood, get all of his gun rights restored. Is that right?
That's right.
And you refused to be complicit in that sequence of events because you had serious concerns. You said, quote, he is the profile of exactly who you would not recommend for this type of relief, citing his history of domestic violent abuse, alcohol abuse, and so on. Is that right?
That is correct.
And you were fired just a few hours after you told the Deputy Attorney General that you could not go along with this request.
Within hours, yes.
Now they're disputing your account. They're calling you a liar. You filed a FOIA request to demonstrate exactly what happened. Have you gotten the documents back yet?
I have not gotten any of the communications between myself and members of Mr. Blanche's staff, which illustrate that everything I have ever said about this matter is true.
And we have some of your contemporaneous communications with your own colleagues that corroborate your account.
That's right. I did, pursuant to FOIA, get some documents that were in possession of the Office of the Pardon Attorney, and they also corroborate my account. All
right. Then they had sent 2 armed marshals to your home to try to intimidate you with a letter telling you not to come today. Why did you decide to come?
I came because I don't want to be complicit in what is happening inside the Department of Justice, which is the misuse of the resources of the department to do political favors for friends of the president, for loyalists, and I just don't believe that that's right, and I don't want to be part of it, so I feel that I need to speak up.
Your courage is heroic to us, and I want to say to you and your family, thank you, and we are with you, and we're going to stand by you. Just this past weekend, we saw another shocking example of retaliation. DOJ suspended the prosecutor who had stated in court that a man, Kilmar Abrego Garcia of Maryland, had been erroneously deported to El Salvador as an administrative error and imprisoned there, where he faces serious danger and gang violence. The judge in the case demanded that the Trump administration seek Garcia's return to the United States, and the administration is, despite confession of its error, arguing to prevent Mr. Garcia's return, saying he's out of the custody of the United States, and they wash the hands of the matter. Ms. Young, is there any doubt in your mind that this prosecutor's suspension was retaliation simply for speaking the truth in court, as this prosecutor was sworn to do?
That's what the facts seem to suggest.
Well, I think that all of these events should stir the conscience of America, and we thank you all for stepping forward now to sound a cry about what's taking place. I yield back to you, Mr. Chairman.
Thank you, Mr. Raskin. I just want to put a fine point, Ms. Oyer, on your testimony. You applied the same standard, did you not, with reference to Mel Gibson, you would apply to anyone. That is, you looked at the facts to determine whether you should recommend restoration of gun rights. You didn't consider friendship with the president or any other impermissible consideration. You just looked at the facts. Is that right?
Well, Mr. Schiff, let me say that this is a project that was not within the normal purview of the Office of the Pardon Attorney. There was no real interest from this administration in considering the work that this office normally does, which is provide advice that is non-political in nature to the president about how to use his constitutional clemency power. So this whole project was something that was very different. It was not the normal work of the Office of the Pardon Attorney, but we jumped in and tried to do our best to support it because we understood that it was a priority of the leadership of the department. And in doing so, a primary concern was considerations of public safety. Would we be able to recommend that someone could safely receive their firearm rights back? And that was my concern in the case that you have discussed, that I did not have enough evidence in front of me to make the recommendation that that could be done safely.
So based on the evidence in front of you, you didn't believe it could be, the restoration of gun rights to Mel Gibson could be done safely?
I did not have enough information to convince me that I could recommend that it could be done safely.
And, you know, your description of the office of the pardon attorney raises another question, which is, was your office consulted on the, 1,550 pardons of the January 6th insurrectionists that were granted by the president?
I learned about those pardons on the news, just like every other American.
And were you the head of that office?
I was.
I remember Pam Bondi testifying, I think in this very room, that she was going to go through those cases one by one. Normally, a pardon request for any of those individuals would have gone to your office for review and examination to determine if there was a grounds or there was acceptance responsibility or service of time or whatnot. Would that have been the process?
The ordinary process is that individuals apply through the Office of the Pardon Attorney. The office carefully vets the applications that we receive, and we look at all of the individualized factors that would support or weigh against a pardon in a particular case, and we make a recommendation on that basis. That's not something we were asked to do in that context, and in fact, it's not something that the office, as of the time of my departure, had been asked to do at all in the context of clemency grants by this administration.
So in the case of Mel Gibson, there was one standard for a friend of the president for a Hollywood celebrity with respect to gun right restoration, regardless of the public safety issue. In the case you testified about, Mr. Croswell, you resigned after your office, attorneys in your office, were asked to dismiss a case against the mayor of New York, which a grand jury found probable cause to believe he had engaged in corrupt acts. Your attorneys were asked, your colleagues were asked to dismiss that case, not because of any flaw in the evidence, not because of any insufficiency in the evidence, but because of some kind of a bargain between the Department of Justice and the mayor regarding an unrelated policy matter, that is immigration. Is that your understanding from the public record?
Senator, the memo that the acting Deputy Attorney General sent to the U.S. Attorney's Office in New York explicitly stated that it wasn't based on the facts or the legal theories on which the case was based. So that was very explicit.
And I was an assistant U.S. attorney for almost 6 years in California, and I just want to underscore how truly extraordinary that is, what you just testified, that a meritorious case is dismissed against a politician, not because of a flaw in the evidence, not because of any prosecutorial misconduct, but because of an interest in having that politician carry the president's water over unrelated policy matters. I never saw anything like that in my almost 6 years in the department. Have you ever seen anything like that in your experience?
Senator, and really from when you start as a federal prosecutor, you're trained that everything is based on the facts and the law. We prosecute based on the facts and the law, and that ensures that we're holding the bad guys accountable and innocent Americans remain free. As long as it's based on the facts and law, that's the best way for us to be doing our job effectively to keep the American people safe.
And I just want to underscore before I turn to Ranking Member Durbin, something you said in your testimony too, which is if the Justice Department believes that it can intervene in the case of friends of the president like Mel Gibson to give him special treatment, or in the case of the mayor of New York to give him special treatment because of unrelated policy help to the president, they can also weaponize that same Justice Department against the president's perceived enemies. And Senator Whitehouse has well demonstrated how that principle has applied in going after funds made available for renewable energy projects under the Inflation Reduction Act. Thank you for your testimony, and I now yield to Senator Durbin, Ranking Member Durbin, for his questions.
Thank you, Senator Schiff. And let me say to all of the witnesses who are here today, this remarkable hearing should help to restore the nation's faith in the democracy and the courage of the witnesses who have come here today to testify and the courage of their family who stand behind them. Ms. Hoyer, it's my understanding that there are guidelines to be considered with pardon petitions. And among those guidelines, there's a requirement that they be granted in part based on, quote, the petitioners demonstrated good conduct for a substantial period of time after conviction and service of sentence, and that, quote, a petitioner should be genuinely desirous of forgiveness rather than vindication. One of the first acts of office, obviously, of President Trump was the full unconditional pardon of 1,600, the number I'm not sure of, but I think it's in that range, of those who participated in the insurrectionist riot here in the Capitol. Most of us at this table were witnesses to those crimes and certainly understood what happened to the men and women in law enforcement who still protect us to this day and risk their lives for us on January 6th. I've taken a look at some of those who were given these pardons and gone through what they have done even since, in the few weeks since that happened. It is outrageous, some of the conduct that has been well documented. My question to you as a pardon attorney at the time, were you consulted on the pardons of the January 6 rioters?
I was not consulted. No member of my office was consulted about those pardons.
What would have happened to the pardon request for January 6 offenders had the normal DOJ pardon process been followed?
Had any of those individuals applied for a pardon, they would have been in due course fully vetted on an individualized basis, and the office would have formed a recommendation about the individual applicants, which would have been provided to the president. The whole role of the office is to ensure that some uniform and consistent standards are provided, and more importantly, the role is to ensure that people who are waiting their turn, who have meritorious cases, that those cases can make their way to the president's desk. Those folks who have access to the White House through the front door, they don't need the help of the Office of the Pardon Attorney to elevate their cause. And there are thousands of ordinary Americans who are seeking the mercy of the president through the clemency process who are not being considered right now because the office is not being consulted. There are individuals who are serving incredibly lengthy sentences under outdated mandatory minimum sentencing laws who are seeking reductions of their sentence, people who have demonstrated rehabilitation over the course of decades in prison. There are people whose family members are writing in pleading for their return home. There are individuals who are in the community doing incredibly well, who have demonstrated rehabilitation and given back over the course of years, who are asking for pardons. And all of those people are on hold because no interaction was happening as of the time of my departure between the Office of the Pardon Attorney and the White House about clemency. The only people being considered for clemency were people who had some sort of inside access, inside track to the White House and could get their cases in front of the president without going through the ordinary process. And that is very concerning, and it causes real reason to lose confidence in the clemency process and real damage to our system of justice.
Have you followed what has happened to those who were given pardons by President Trump who were engaged in assaulting law enforcement here on Capitol Hill? Have you followed any of the cases, what has happened to them since?
I have, sir.
And what have you seen?
Well, there seems to be chaos in litigation that's happening around the country about determining what the intended scope of the pardons was. That's one thing I've observed, and that's one way that you can tell that my office was not involved. Had we been involved, we would have written the paperwork in an intelligible, clear way, so there was no ambiguity about what it meant. But instead, there is litigation happening around the country in which the department is taking inconsistent positions and reversing itself about what those pardons mean. They have created a lot of chaos in a lot of different ways, and that is not the way the process is intended to work.
At least one of these people has been shot dead assaulting a police officer. Are you aware of that?
I don't want to overstep the area of my knowledge. I've seen things in the news, but I don't have any personal knowledge about the facts of that case or others.
Mr. Chairman, let me conclude by saying that last week our New Jersey colleague showed strength and resolve and courage to stand for more than 25 hours to speak for fairness and justice. He made history. This hearing continues in that spirit. Thank you all for your courage in attending.
I'd like to recognize Mr. Nadler from New York for his questioning.
Thank you, Mr. Chairman, and thank you for holding this important hearing, shining a light on the most flawless administration in history. Donald Trump may pride himself on mastering the art of the deal. What he has really perfected is the art of the shakedown. Look no further than the corrupt quid pro quo with the mayor of my own city of New York, Eric Adams. After cozying up to Donald Trump, the charges against him were dismissed without prejudice. Was it because the prosecutors determined there wasn't sufficient evidence to bring him to trial? No, it was because Donald Trump wanted something from him. He wanted the mayor to help carry out his extreme immigration agenda against the wishes and the well-being of millions of New Yorkers. So he and his administration orchestrated a corrupt bargain to drop the charges in exchange for the mayor doing his dirty work, and by dismissing the charges without prejudice, meaning they could be reinstated at any time, effectively kept the mayor on the hook to assure he did whatever Trump wanted. And of course, there is the president's effort to bully and intimidate major law firms that employ lawyers who dared to try to hold him accountable when they served in government. His campaign of retribution is a classic case of extortion, threatening the livelihood of these firms unless they do his bidding. If it weren't for the Supreme Court's immunity ruling last year, Trump could be prosecuted for extortion, violation of the Hobbs Act. Of course, Trump's captive GOJ would not prosecute in any event. Mr. Crosswell, thank you for being here. In your testimony, you told us about the reasons why you resigned. Perhaps you can elaborate. I know you did not work directly on the case, but how would you characterize the evidence you have seen publicly reported against Mayor Adams? Was it substantial? Was it overwhelming? What were some of the most egregious examples of public corruption you saw in this matter, particularly as it related to the mayor?
Thank you for the question, Congressman. You know, the case had not been dismissed with prejudice by Judge Ho last week. Mayor Adams would have had his trial, and like any other citizen, he'd be presumed innocent until proven guilty. That said, it was obviously deeply concerning that this was being dismissed for reasons that had nothing to do with the evidence. And so in terms of my own resignation, that was concerning. I probably would still be a public integrity had it not been for the fact that then five of my colleagues, incredibly talented, dedicated, and friends of mine with deep integrity then also had to resign because they wouldn't sign the order. And that really kind of goes back to my experience as a Marine officer. You take care of the people that work for you and you expect them to do the right thing. You don't force them to resign over it.
But based on public reports, you don't want to characterize the strength of the evidence at this point in that case?
Sorry?
I said based on public reports, you don't want to characterize the strength of the evidence in the case? If
Congressman, if everything that was alleged in the indictment would have been able to be proven by the prosecutors, that looked like it would be a strong case.
Thank you, Mr. Croswell. Ms. Cohen, thank you for being here and sharing your story with us. I know you mentioned why you left Skadden Arps in your testimony. Can you tell us more about why you think the law firm gave in to the president's demands, how intense the pressure is coming from the administration, and how dangerous that type of pressure is to the rule of law in this country?
Absolutely, thank you. I think that the strength of the pressure is exponentially higher because law firms are not standing together and are instead treating the president's attacks as if they are normal course and not something that would easily be challenged in a court. And so I think that the pressure here comes from presuming that standing up to the president means you fall out of his favor. I think that ultimately, because these executive orders have pointed to past representation, particularly challenging the government, it's massively dissuading large corporate law firms from taking cases that might be viewed as problematic to the Trump administration. They were instrumental in 2016 in bringing challenges against unconstitutional action, but it's not limited to 2016. Large corporate law firms provide a significant amount of financial and staffing resources to public interest organizations that are challenging unconstitutional actions under both Democratic and Republican presidents. They also provide an immense amount of direct services work, like to migrants seeking asylum and to veterans seeking benefits, things that the president alleges may be frivolous or counter to his interests.
Thank you. And if lawyers are too intimidated to take on the administration when it clearly violates the law, then what remedy do any of us have to enforce the law and protect our rights from a president with dictatorial demands?
Given the nature of our adversarial system, we have almost no hope. That's why we have to act now.
And
Thank
do
you.
think
I think we've got to shift back to the Senate side now because we're impinging on their time. So.
Thank you, Mr. Nadler, and I regret to announce that the Chief Justice, during the course of the hearing, Chief Justice Roberts, has indefinitely blocked the court order requiring the return of Kilmore Abrego Garcia. This ruling came out during the course of this hearing. So we now have the deportation of someone in violation of court order, and a further court ordering his return has now been countermanded by the Chief Justice of the